Jameel.
Yep. All right. Let me get this straight. All right. All right. Good afternoon, everybody, and welcome back from lunch. We're going to begin our afternoon session discussing FISA and the modifications to FISA. Our panel this afternoon, we have Tien, who is with the senior staff attorney with the Electronic Frontier Foundation, specializing in free speech and privacy law. We also have Jameel Jaffer, who is the director of the National Security Project with the American Civil Liberties Union, including doing and directing all of the litigation that the ACLU is involved in, including the litigation over FISA and the recent amendments. And we also have then Professor Ray Koo from Case Western Reserve University, teaches among a number of other things, constitutional law, and copyright, which I'm sure there's some FISA connection between copyright and copyright law and FISA. So we're going to begin our presentation this morning, or this afternoon, much rather, I'm sure, listen to what they have to say. After the presentation, there will be a period for question and answers, and then we are going to take a short break for the final session this afternoon. So without further ado, Mr. Tien.
Where do you left?
No, he's here.
Hi, so what I'm going to talk about today is decidedly non-academic, I think. My organization, the Electronic Frontier Foundation, since 2006 has been litigating about the so-called terrorist surveillance program, and not just the part that the Bush administration has admitted to, but also about the data mining and data collection aspects that form a data surveillance program, as Paul Rosenzweig talked about earlier. But even though this is something that people have talked a lot about, and especially talked about the constitutional issues and the separation of powers issues, I'm going to really take more of a litigator's perspective, as someone who's actually been trying to get at some of this stuff. How do secrecy doctrines, and in particular the state secrets privilege, how does that distort the way that ordinary litigation progresses? Now, it's obvious that at some level, some degree of national security secrecy is always going to exist. And the executive is clearly resisting both legislative and judicial intrusions on their control of national security secrets. So what I want to talk about is really give you a detailed picture of some of the problems that are created. And I will not be talking about some of the more, well-known or more highly publicized aspects. I will not be talking about criminal cases or Guantanamo habeas or terrorist detention. These are all very different kinds of issues from a state secrets perspective and from a litigation perspective than ours, which are fundamentally civil cases where plaintiffs who believe they've been surveilled are trying to seek some kind of judgment against either a telecommunications carrier or against the government itself. And the reason why, of course, this matters from a state secrets privilege perspective is because the burden of proof lies with the plaintiff to establish the prima facie case. Whereas in a criminal prosecution or in a lot of these other situations, the interest of the person being detained or whatever is really ridiculously clear, and so you don't have the same kinds of issues that we have. Doctrinally or legally, I think there are two very rough sets of problems. The first involves Congress, the question of legislative power over executive assertions of the state secrets privilege. And the second involves the courts, and thus inherently the adversary process, both lawyers and their clients. So from a plaintiff's perspective, we have a really sort of simple-minded way of looking at things. People are being harmed by unlawful surveillance. Two, Congress has no enforcement arm, right? Our lawsuits are based on private rights of action that were created by Congress in the FISA, in the Wiretap Act, in the Stored Communications Act. But those kinds of checks, those kinds of accountability mechanisms fundamentally rely on the existence of private litigants and litigation. And then sort of the third point, or the corollary to that point, is that courts, the judicial branch, is never in itself the full check, because our courts are not roving commissions to do good. Their power only gets invoked by parties in litigation. So they also need us. And I think one of my basic point here is that because the checks of Congress and the courts through private rights of action need private litigants and litigation, therefore you have to have some sort of structural or institutional capacity given to litigants in order to actually make any of those checks on the executive real. Now, so I'll start by talking about what I think is the most obvious state secrets privilege reform issue, and that's the preemption of the state secrets privilege. The state secrets privilege is something that is almost universally regarded by the courts as a common law evidentiary privilege, although we have litigated with the government the issue of whether it is really a common law privilege or whether or not it is constitutional. In most of our cases, and when I say our cases, I'm really referring to all of the cases in the Northern District of California and in a few other venues that are challenging the wiretapping program and the call detail records program. In most of these cases, what the courts have been saying is it's just a privilege, and Congress can actually reform it. And there are sort of three ways of looking at it on the table. One is in the existing statutes, such as in the FISA. There is also a Ninth Circuit decision outstanding in a case involving extraordinary rendition that was brought by the ACLU, known as Mohammed versus Jefferson Data Plan. And then there is pending legislation before Congress, S-417, the State Secrets Protection Act. And I'll talk about those more in detail later. Then the other set of issues are what I was talking about, the litigation issues caused by the state secrets privilege. And that really falls into just two main categories. One is the issue of what I will call threshold dismissal. The way the state secrets privilege works is that the government either asserts it because it's already a party to the litigation, or it intervenes in litigation between two private parties and asserts it with respect to information that may or may not come up in the case. And what typically happens when the government asserts the state secrets privilege in civil litigation is that it seeks to dismiss the case at the outset. There are a number of roads by which it can do so. One is known as the Totten Doctrine, very limited, refers to contracts for espionage services. Another is really sort of the big bugaboo we faced all along, which was the idea that a case could have as its very subject matter a state secret. And thus, if the very subject matter of a case were deemed to be a state secret, so they argued, then it could be dismissed at the outset without discovery. There are a number of other issues there, but that gives you the flavor. If you get past the threshold dismissal problem, then you get into a whole bunch of issues relating to discovery. How can you actually do the things that litigants normally do to proceed with litigation when the state secrets privilege casts a shadow over virtually every aspect of the case? So now I want to go into a little bit more detail about the preemption issue. Now, we argued that the Foreign Intelligence Surveillance Act actually preempted the state secrets privilege. And as I mentioned, that's because there are private rights of action built into all of these statutes, which suggests that there has to be some way that litigants could get the information needed to litigate. And second, the statutes clearly provided for certain kinds of disclosure of information pursuant to legal process. And third, that within the FISA itself, there is a section, 1806F, that clearly sets out a procedure for in-camera ex parte judicial review of the legality of electronic surveillance. Now, in our case, this was originally sort of tossed aside or elided mainly because our judge, Judge Walker, was able to find that the very subject matter of our case was not a state secret. That is, the government was arguing that whether or not any telecommunications carrier assisted the government in carrying out its surveillance was in itself a state secret that could be neither confirmed nor denied. And that argument was rejected. So once that happened, then we were no longer in the sort of easy area of a threshold dismissal, and we could start to argue about how the state secrets privilege will be applied more at a more granular level. But Judge Walker ended up being forced to deal with the preemption issue in another case called Al-Haramain, where the standing of the private parties was all tied to a single document that had been inadvertently revealed to them. And that document was essentially, or as far as we know, because it turned out to be a state secret, to detail the wiretapping of these individuals. So the way that this happened then was the Ninth Circuit found, yes, indeed, it is a state secret. Plaintiffs, you're going to lose because you can't prove your standing without it unless, and this was the remand back to the district court, unless the district court finds that FISA, in fact, does preempt the state secrets privilege. And that's what Judge Walker did find. So if you have preemption of the state secrets privilege, then what? Well, one of the big issues here is what the government continually argued, that if you allow preemption to be handled so cavalierly, as it were, that a litigant could simply bring a claim and then bypass the state secrets privilege, then that's going to lead to quite a few fishing expeditions by plaintiffs. The courts have always taken that sort of seriously, but Judge Walker in the MDL cases found that, well, there's a gatekeeping notion, and that notion is the idea that you have to be an aggrieved person in order to actually trigger this special procedure. Now, we ended up, we have not had to deal with this yet. The Al-Haramain folks did, and they were put to the test because the way that the courts ended up resolving it was to say that you have to make a showing of aggrieved person status with unclassified evidence. That is, they were not allowed to yet to invoke the discovery mechanisms. They were able to do so, but in Judge Walker's opinion, but this is where that case sort of ends up at a standstill. And I'm going to talk about that in a little bit of detail because I think it sort of underscores all the litigation problems. So first of all, Judge Walker ruled in Al-Haramain's favor to say that, yes, they had established that they were aggrieved persons. So what next? Well, Judge Walker said, well, I'm going to put myself in a position to review the sealed document, which is the sort of the crown jewels in that case. In the meantime, I'm going to order the Justice Department to do some declassification review to see if the Obama administration is looking at this any differently than the Bush administration did. And third, I'm ordering the Justice Department to begin the process of vetting counsel for clearances that are needed to litigate. And this is where the government balked big time. It went ballistic, basically. They did not want to do that. They sought to get a stay pending appeal. They sought to appeal the court's ruling. They were rebuffed several times. Judge Walker said, no, it's not a final judgment. This is, and I'm not going to go ahead and authorize an interlocutory appeal here. They asked the Ninth Circuit. The Ninth Circuit said, well, Judge Walker's right. It's not a final judgment. You have no appeal of right, and we're not going to authorize an interlocutory appeal here. This actually went on for several months to the point where the government got this far, and what I mean is they went ahead and did the background investigations on Al-Haramain's attorneys and said, okay, they're cleared. Their background checks are fine. But, you know, they don't have a need to know. And in our system, you can't just be cleared, you actually have to have a need to know. And Judge Walker's going, well, wait a minute, I basically have already told you that they have a need to know because that's what's needed to make the adversary process work. And the Justice Department's response is, well, no, because that's an inherent executive power to decide whether or not someone has a need to know this kind of sensitive information, and we've already decided that they don't. This, went on to the point where there was an order to show cause from the district court as to why they had not complied with the court's order. And for a while, we thought that this was going to be, quite the fireworks. And indeed, in the order to show cause, Judge Walker said, well, show me why I shouldn't just say that the government can no longer oppose, can no longer deny the aggrieved person's status that they were disputing. And second, why I shouldn't just, because of your sanctionable conduct, deem the liability of the government established as a result and proceed directly to the damages and remedies phase. Now, at the end, I guess you'd have to say that Judge Walker blinked because he didn't go that far. And what they ended up doing was ordering the plaintiffs in Al-Haramain to move for summary judgment without discovery and without the use of the classified evidence. But he warned that if the defendants did rely on the sealed document or other classified evidence, then the court would go ahead and order a protective order and require them to produce the evidence to the plaintiffs. And that is currently pending before Judge Walker as of a hearing in late September. So what I think this illustrates is a number of recurring issues. You have a very stubborn, recalcitrant government that puts into question the issue of how much power an Article III court really has in this area over the governmental party. Can it order security clearances? Can it craft protective orders that will safeguard the litigation? And finally, a very interesting question, how much does the private party's actual knowledge here affect the way that those decisions can be made? Remember that Al-Haramain had the sealed document. They had inadvertently received it. They knew what was in it. Then it was essentially taken away from them. But they still know it in their heads. But right now, they're not being allowed to use it. So that's the situation that we have under a clear statutory preemption under FISA. And as you can see, it's not particularly satisfactory. Now, suppose we took a different approach, and that's the approach that the Ninth Circuit took in the Mohammed versus Jepson data plan case. That is, there is no counterpart to 1806F in the extraordinary rendition cases. They have no statute from Congress that preempts the state secrets privilege. But what the Ninth Circuit did was, in some ways, as good, reinterpreting the state secrets privilege, the Ninth Circuit found that you cannot do a threshold dismissal of a case under the state secrets privilege unless it falls within that very small category of espionage cases. And it said that the government could not force the courts to do what I call looking down the road. And by that I mean one of the common tactics in this area by the government is to say, well, because there are state secrets, bad things are going to happen. They're not going to be able to prove their standing. Maybe they could make allegations of it good enough for a motion to dismiss. Maybe they can create a triable issue of fact good enough for summary judgment, but they sure as hell can't do it by the time of trial. And since they can't get it by trial because of our control over it, then we're going to have to, then you might as well dismiss anyway. That was something that the Ninth Circuit in the Mohammed case said, no, we're going to require actual discovery requests. It's not going to be hypothetical. We're going to require that evidence be looked at on an item-by-item basis. So is that really going to work? I'm not sure. I think that with a stubborn government, you're going to have the same kinds of problems we saw even under FISA, but it will be interesting to see. And that decision is up in the Ninth Circuit right now with a pending consideration for en banc review. And as far as I know, the Ninth Circuit hasn't decided to take it yet en banc. So how would the final, the third part of this, the State Secrets Protection Act, solve these problems? Well, the first thing it would do is it would create a tougher test for state secrets in the first place, that it would require that they have a significant harm to national security. It would address the threshold dismissal problem by saying that all the procedures have to run their course. It avoids the aggrieved person gatekeeper problem by requiring the government to provide the court, when it asserts the state secrets privilege, with affidavits, both unclassified and classified. And perhaps most important, it actually requires them to submit all of the evidence that they claim would be privileged. So there are a number of other provisions, but I'm, I guess, about out of time. So I will just say that it creates a nice procedural framework that addresses a lot of the litigation problems that we've experienced and that anyone else litigating in this area is going to experience. And yet, I'm still, at the end, not particularly optimistic, even if it did pass, because I don't know how well it's going to actually handle the problem of real-world discovery when you're actually trying to do depositions, when you're actually trying to do interrogatories. How hard is it going to be to actually carry out sort of ordinary civil litigation when there's this ever-present concern about what secrets are or are not going to be disclosed? Thank you.
All right, thanks for coming back after lunch. As Lee says, the state secrets privilege is a real problem for plaintiffs who want to sue over government surveillance. And the problem is that the information you need, or the information the government says you need in order to establish standing, is information that's in the hands of the government and only in the hands of the government. You need to be able to prove, according to the government, you need to be able to prove that your own communications were wiretapped, were monitored under the program that you're seeking to challenge. And it's very difficult for a surveillance plaintiff to prove that because the government conducts all of the surveillance in secret. And if you go into court and you demand the information that the government says is necessary to establish standing, what the government says is we can't give you that information or we won't give you that information, and therefore the case has to be dismissed. So state secrets is an obstacle, maybe the primary obstacle to suits over government surveillance programs, secret government surveillance programs. And it is also the obstacle, therefore, to judicial scrutiny of those government surveillance programs. I want to talk about how this actually plays out in some of the litigation that's taken place over the last few years. The fact that a plaintiff can't prove that his or her communications were monitored under a government surveillance program doesn't necessarily mean that that plaintiff hasn't suffered an injury because of the government surveillance. There are a lot of injuries that flow from government surveillance programs that have nothing to do or little to do with the actual intrusion, the actual privacy intrusion itself. You're all, I think, probably familiar with the basic outlines of the NSA warrantless wiretapping program that the President Bush inaugurated after the 9/11 attacks. But just to refresh your recollection, so and I think Ray's going to talk a little more about this later, so I'll try not to go into too much detail. But so the program was something that President Bush authorized in the weeks after 9/11. And it was a program under which the National Security Agency engaged in warrantless wiretapping of Americans' phone calls. And the idea was that the NSA, a shift supervisor of the NSA, would decide whether there were reasonable grounds to believe that one party to an international phone call, and by international I mean one end domestic, one end international, one party to that phone call was somehow associated with Al-Qaeda. And if the NSA's shift supervisor made that determination, then the executive branch would wiretap that phone call, would monitor that particular communication. And it was a program that operated without judicial oversight of any kind. It was entirely an executive branch program. At the time that the program was authorized, there was a statute, the Foreign Intelligence Surveillance Act, which is a statute that's been around in one form or another since 1978. And that statute generally prohibits warrantless wiretapping. That's a vast oversimplification, but it generally prohibits warrantless wiretapping. And there was no serious dispute that this program operated in violation of FISA. The way that FISA is supposed to work is that the executive branch, when it wants to monitor a particular person's phone calls, goes to the FISA court, which is a court made up of 11 judges, goes to one of the judges of the FISA court and presents an application for a FISA warrant, a Foreign Intelligence Surveillance warrant, and the application is evaluated for something called foreign intelligence probable cause, whether or not the target of the surveillance is reasonably believed, or there's probable cause to believe that that person is a foreign agent, an agent of a foreign power or a foreign power. And foreign agent is defined broadly enough to encompass international terrorists. So that was the statutory framework that existed when the program was authorized. The program operated in violation of that framework. Now we represented, the ACLU represented a set of plaintiffs, journalists, lawyers, human rights researchers, in a challenge to that program, which we brought in 2005 after the New York Times disclosed the existence of the program. And we brought the suit knowing that if we were to go into court and argue that we should have that we had standing because our own communications had been monitored, the government's response would be, well, prove that your own communications have been monitored. And we would have to say, well, we can't prove it. We need this information from you in discovery, and the government would invoke the state secrets privilege. So rather than go down that road, what we did was assert other injuries. We pointed not to the privacy intrusion itself. We pointed not to the fact or the speculation that our plaintiffs' communications have been monitored. Instead, we pointed to what are sometimes called collateral or indirect injuries. And in particular, the lawyer plaintiffs pointed out that they relied on confidential communications with their clients. Journalist plaintiffs said that they relied on confidential communications with sources, and that without the assurance of confidentiality, they couldn't engage in entirely legitimate work that their professional obligations required them to do. And we also submitted from a legal ethics expert an affidavit saying that in these circumstances, when there is a program of this kind, a surveillance program of this kind, and there are reasons to believe that lawyers' communications may be monitored, the lawyers are not only acting reasonably in taking measures to protect the confidentiality of their communications, but they are required, they're ethically required to take measures to protect the confidentiality of their communications. And those measures include, in some instances, foregoing communications altogether with certain people whose communications are thought to be monitored, and in other circumstances, traveling long distances to gather information in person that you might otherwise have been able to gather by email or telephone. So that was the factual proffer that we made to the district court, saying these are the kinds of injuries we're asserting. We're not asserting that our own communications have been monitored. They may well have been monitored, but we can't prove it. But what we are asserting, the injury that we're asserting and that we think is sufficient to support standing, is this collateral injury, the cost that this surveillance program has imposed on us, notwithstanding the fact that we can't prove our own communications have been monitored. The district court agreed with us. The district court said that the plaintiffs had standing to challenge the surveillance program, found that the program was operating in violation of the Foreign Intelligence Surveillance Act, found that the program was operating in violation of the principle of separation of powers, and found also that the program violated the First and Fourth Amendments. So it was from our perspective, it was a clean sweep. Unfortunately, the Sixth Circuit, the appeals court, two of the three judges on that court found that we did not have standing, and this is what they said. They said that the injuries that your plaintiffs have suffered are self-imposed injuries. They're injuries that they caused themselves by taking these measures to protect the confidentiality of their communications. Nobody forced them to take long trips to gather information that they might otherwise have gathered by phone or by email. Nobody forced them to forego communications simply because of the fear that the government might be monitoring them. Those were decisions that your plaintiffs made on their own. And the other thing that the two judges in the majority pointed to is a case called Laird v. Tatum, which is a 1972 Supreme Court case. I said earlier that state secrets was an obstacle and perhaps the principal obstacle to challenges to government surveillance programs. I think the other contender for that slot is Laird v. Tatum, this Supreme Court case. Laird v. Tatum involved a challenge to an Army data gathering program. It was about gathering information about groups and individuals who were protesting the Army's activities abroad. And the plaintiffs challenged the program, saying that this gathering of information about us chills our First Amendment rights. It discourages us from exercising rights that the First Amendment protects, rights of association, the right to free expression. And the Supreme Court said that the plaintiffs in that case did not have standing to challenge that Army data gathering program. The Supreme Court said two things. First, that the plaintiffs' response to that program, the fact that they had been discouraged from exercising their First Amendment rights, was unreasonable. It was an unreasonable response to what the government was doing. And the Supreme Court characterized what the government was doing in that case as merely gathering information that anyone could have gathered from the public newspapers. And then the other thing that the Supreme Court said was that the plaintiffs had failed to point to any concrete injury. Instead, the plaintiffs had pointed only to what the Supreme Court called a subjective chill. And those two phrases, subjective chill and concrete injury, have turned out to be where all the action is in all of these surveillance cases, or all the action has been in all the surveillance cases since 1972. So the Sixth Circuit, in rejecting our argument that we had standing, relied on Laird v. Tatum and on this argument about self-imposed injuries. There's a dissent. The dissent points out that we had submitted this expert declaration that explained that the plaintiffs were not undertaking these measures to protect the confidentiality of their communications of their own accord. They were ethically required to do that. And the plaintiffs themselves had asserted that, and the government hadn't introduced any affidavits on the other side. So the record was uncontroverted that we were not only taking these measures, but were required to take these measures. The dissent also points out that the injury that we had suffered wasn't the kind of subjective chill that was at issue in the Laird v. Tatum case. In Laird v. Tatum, the plaintiffs said that they were discouraged, but they didn't point to any concrete evidence of that of the injury that they were asserting. In our case, by contrast, the dissent said we had pointed to concrete injuries in the form of foregone communications, in the form of the cost of travel. So there were very concrete things that we had pointed to, and we could say we had suffered these injuries as a direct result of the government surveillance program. But of course, that was a dissent, and dissents don't matter. So the president's surveillance program on the eve of the Sixth Circuit argument, so on the eve of the appeals court argument, the Attorney General announced that the program was being, in one sense, shut down and brought within the ambit of the Foreign Intelligence Surveillance Court. They said that they were no longer going to rely on this warrantless, executive branch only surveillance program. Instead, they would go to the Foreign Intelligence Surveillance Court and ask for some form of warrant. It's still unclear exactly what they intended to do, but when they shut down the program, we called for a congressional investigation into the violations of FISA over the previous 5 years. Rather than conduct the investigation that we said Congress ought to conduct, Congress instead passed a statute ratifying everything that the president had done in the previous 5 years. And I'm making a complicated story relatively simple, but last summer, 2008, Congress passed a law that not just ratifies the warrantless surveillance that took place between 2001 and 2008, but also expands the authority of the executive branch to engage in warrantless surveillance. That act is called the FISA Amendments Act. How much time do I have? 5? All right. Okay, that act is called the FISA Amendments Act. And the way it works is this. It removes the individualized suspicion requirement altogether. So rather than go to the Foreign Intelligence Surveillance Court and ask for a warrant based on foreign intelligence probable cause, what happens now is that the Attorney General can go to the Foreign Intelligence Surveillance Court and propose a program of surveillance that may last for up to 1 year. The surveillance has to be conducted for the purpose of gathering foreign intelligence, but beyond that, the only requirement, the only substantive requirement, is that the targets of the surveillance be located abroad. Now, the fact that the targets are located abroad doesn't mean that Americans' communications aren't being monitored. Theoretically, the government could say that the target of our surveillance is the City of London, and then the government could monitor every communication between London and the United States. Now, I don't think that the government has the capacity, the technological capacity, this year, although maybe next year it will. So I don't think that's what's going on now, but I don't think it's individualized surveillance either. I think it's much more, we're now talking, rather than about individuals, we're talking about geographical areas. We're talking, if not about the City of London, we're talking about geographical areas in Pakistan or in Afghanistan. And the government is siphoning up all communications between the United States and those places on the authority of the FISA Amendments Act. So there's no requirement of individualized suspicion, no requirement of probable cause, no requirement that the government identify the facilities to be monitored. So, in other words, you don't have to list for the Foreign Intelligence Surveillance Court the phone numbers you're intercepting or the email addresses you're monitoring. You can go to the Foreign Intelligence Surveillance Court and just say, we want communications of people located in Afghanistan, and then you pick up all communications between Afghanistan and the United States. Again, I'm not talking. I don't know enough about the technological capabilities to know whether that's possible or not, but it's certainly plausible under the language of the law. We sued over that act too. And we've asserted the same standing theory. We're now in a different court, so essentially we're arguing that the dissent was right in the Sixth Circuit and the majority got it wrong. We'll see how that goes. We're going to the Second Circuit in the next few months. But I just want to point out in closing what the consequence is if the courts accept this theory, the government's theory, that the only people who can challenge government surveillance, who can challenge secret government surveillance programs, are people who can show their own communications have been monitored. To say that the only people who can challenge these programs are people who can show their own communications have been monitored is to say that these programs can't be challenged at all. We will never have the information that the government says we need. We will never be able to prove that our plaintiffs were wiretapped under the FISA Amendments Act. There is, in theory, the possibility that the government will prosecute somebody based on evidence obtained under the FISA Amendments Act. And the Act includes a provision that requires the government to disclose if it's relying on evidence obtained through the Act. But I would just point out that over the last 8 years, the government has not, in even one case, acknowledged that it is relying on evidence obtained through the President's warrantless wiretapping program. So for 8 years, the government has been able to insulate from scrutiny, from judicial scrutiny, that program of warrantless surveillance. And who knows how long it will be able to insulate the FISA Amendments Act in the same way. Even if the government does one day introduce evidence against somebody in a criminal proceeding that was obtained through the FISA Amendments Act, I question whether it really makes sense to say to the vast majority of people who will never be prosecuted that their own privacy rights can't be vindicated at all until the government uses that act against somebody else. To me, the intrusion is the surveillance itself. And it doesn't make sense for the government to say, and for the courts to accept, that the people against whom the government is using this this surveillance statute can't challenge the statute unless the government prosecutes somebody else. Finally, somebody said, maybe it was Paul, somebody quoted the line about the Fourth Amendment being dead. Was that your line? Somebody said Fourth Amendment is dead. All right.
Privacy.
Privacy is dead. Yeah. Well, this is.
That wasn't me. That was Scott Jameel.
All right. So this is the line. This is a line that that's used quite a bit, and the line is usually a reference to substantive Fourth Amendment law. The theory being that the Fourth Amendment has been watered down so much that it's almost meaningless, and that may be true. But I think that the Fourth Amendment in this context, if the courts accept this standing theory, will be dead for an entirely different reason. It will be dead because the Fourth Amendment won't be enforceable at all. There's no way to get a court to review these surveillance statutes, and the consequence is that privacy rights are left to the mercy of the political branches. Okay, thanks.
All right, thank you all for being here, and thank you, Bob, for inviting me to this talk and this symposium, and I've very much enjoyed the presentation so far. Now for something completely different. Being the only academic on this particular panel, I get the benefit of talking about the issues of privacy, security, and constitutionality of the President's surveillance program as an aspect of FISA and beyond, without having to worry about the real-world implications of actually can we vindicate these rights to the extent that they're found to exist. Now, I've entitled my talk in what will be the paper here, Unlimited Power, Why the President's Warrantless Surveillance Program is Unconstitutional. And I wanted to start with kind of what we may often think of when we think of unlimited power. The tyrant, right? The evil villain, the villain that is so twisted with power that they're essentially a monster, right? And that power is exhibited in almost supernatural form and ability. Now, obviously, that's not what we're talking about here or in the reality of the problems that we're facing today. Though this, in some ways, this might be equally scary for many in the room compared to the Emperor Palpatine from Star Wars. This was originally DARPA's idea of Total Information Awareness, or the Information Awareness Office, which in many respects went to the data valence that Paul was discussing earlier, in the sense that in this information age, one of the critical desires of government, and many of the critical powers that we, in many respects, want government to exercise, is the gathering and analysis, and as efficiently as possible, of all sorts of information, right? And obviously, national security has become, if not has always been, one of the principal interests in which this has been raised. Right, so that was the government's view of this. So that was their own logo. The kind of online phenomena, of course, has taken it to a slightly different view. For those of you who are fans of Orwell or Fear, Big Brother, the essential problem for us in many respects today is the National Security Agency is in fact surveilling us in many respects. Right, and this is not new. I mean, programs of these sorts, whether they were when the internet first dawned, whether they were called carnivore, or whether they were considered net-wide searches, or involved government programs involving what they wanted to call the magic lanterns, in which we would search out the important critical criminal information that was available on the internet, have always been part of the toolbox that government and especially law enforcement have tried to use and exercise. Right, now, the problem, of course, for us, at least in the debate, is often it's created as a conflict between privacy, and Michael was making this point earlier. It's often created as a conflict between privacy and security, right? So we lose, right? It's a trade-off. We're giving up and sacrificing national security, public security, individual security, to the extent that we're trying to vindicate rights like privacy. And along these lines, Justice Brennan, a quote from him, is quite typical of this. And the idea is that electronic surveillance makes the police omniscient, and police omniscience is one of the most effective tools of tyranny. Right? And that often from the privacy community is our criticism. Right? I mean, this is complete information, and complete information essentially leads to complete control. And that is one way of looking at this problem. I would like to suggest that it's not perhaps the most useful way of looking at this problem, at least right now, and in many respects has for quite some time, since, in fact, Katz versus United States, ultimately subsumed a more important question, both for us politically, constitutionally, and from a security perspective. And so I would like to suggest that a more appropriate quote is provided by Justice Robert Jackson from the Youngstown steel seizure cases, where he says, "Ours is a government of laws, not of men. We submit ourselves to rulers only if under rules." And so since, even before 9/11 and after 9/11, my work in the privacy area has been essentially trying to shift the frame that we use to think about electronic surveillance or government power in general in this area away from privacy. Right? And you'll see why in a moment. So what I'm talking about today, luckily Jameel has done quite a good job of describing the more detailed features of FISA as well as the FISA Authorization Act. And what we're talking about is the President's Surveillance Program, in part. Right, now, this had two components. Right? One is the terrorist surveillance program, which most people find completely unobjectionable, the idea that we're actually monitoring terrorist communications outside the borders of the United States in order to preempt terrorist activities. But the problem that we've discovered through the Inspector General Office reports and other news reports is that, well, there are a whole category of other activities that are loosely categorized as other intelligence activities that have also been part and parcel of the President's surveillance program. And what of these included? Well, as far as we can tell, given the state secrecies problem that the prior two speakers have both dealt with so well, is that we can get a sense that not just foreign but domestic information is being gathered and monitored at an unprecedented scale. And that is not just oral communication, right, audible communication, but also email and internet data. Why? In part because, well, as some people will tell you, in the old days it was easy to just get oral communication, our telephone communications. Why? The communications were sent up by satellite. The NSA could grab the satellites, see any number of Hollywood movies about this. But now that we've gone to digital communication and fiber optic communication, all of this traffic is essentially bundled together. And one interpretation is that the NSA is tapping at multiple points throughout the country as well as outside the borders of this country in order to gather this information. Now, some of this, of course, will be extraterritorial information, but some of it will be domestic as well. So the problem for me is, well, can they do this, right? I mean, clearly there are very, very compelling reasons, right? 9/11 itself being a clear example of a compelling reason to have the government engage in this activity. And from my perspective, the question is how. And I think for many of us, the question isn't whether government should do things to investigate and keep us safe, but how should government engage in those activities, right? So one of the questions we ask with the President's surveillance program is, did the President have the legal authority to create and enact and tell the NSA to engage in this activity? So for our purposes, there are essentially two time periods that I want to focus on. One is essentially the entire time period that the program was fundamentally in operation as far as we could tell, 2001 through 2007. Now, 2007 is an interesting break point because that is when Congress actually passed the Protect America Act, which was the first specific piece of legislation authorizing this type of activity. I have bracketed the authorization for use of military force in there. For those of you who followed kind of the inside baseball of the debate between John Yoo and Jack Goldsmith about presidential authority in this area, John Yoo had originally argued in the Office of Legal Counsel that legislation was unnecessary, right? This is essentially an inherent part of the executive branch's power to engage in this type of activity, that we pick the tools that the executive branch needs to enforce the laws, and we exercise those in order to defend our country. Jack Goldsmith disagreed, but only slightly, and he said, well, we actually need some legislative authorization for that. And his argument, at least, was that the authorization for use of military force post 9/11 gave the president that authorization, right? Even though the AUMF says nothing about surveillance activities or any other activities, let alone creating any specific exemption under the Foreign Intelligence Surveillance Act. Now, then, of course, as Jameel talked about earlier, well, we have the FISA Amendment Act in 2008. And as Jameel has said, that one of the things that it did was essentially authorize retroactively all of the activity that occurred before. But it did it in a very interesting way, as he suggested, and it eliminated the individual cause requirement or suspicion requirement for the targets of the surveillance. So what I want to suggest is that there are a couple of problems here, and they're the same regardless of what period we're really talking about in many ways. The first is just a practical one, right? And that is, as long as the U.S. The limitations are essentially that as long as a U.S. person and U.S. communications are not intentionally targeted, it's okay to gather that information, right? And so we've heard that President Clinton, journalists, and other social activists have had their conversations recorded and monitored by the NSA under this program. It is not limited to al-Qaeda or to known or suspected terrorists, which in many respects might make plenty of sense from a law enforcement perspective. And more importantly, in many respects, regardless of the period we're talking about or the statute, there is essentially no judicial oversight over individual surveillance decisions. When I wrote, this talk is based on an article I wrote back in 2001, which was then published in 2002. I had left the question open, and which was essentially, well, what happens in many instances if Congress or the legislature were to give the executive government a blank check in order to engage in surveillance activity? And obviously, as an academic, you hope those questions remain academic, but with the FISA Amendment Act, Congress actually gave me a perfect foil for addressing the question, what happens when Congress gives the president a blank check? Right? And so that gets to this point of, is the PSP constitutional? And the traditional way, as we've already heard in the several panels this morning, of dealing with this question or asking this question is through the lens of the Fourth Amendment. Right? And that says that the right of the people to be secure in their persons, houses, papers, etc., shall not be violated, and no warrants shall issue but upon probable cause. Now, the difficulty or the challenge has been, right, even though the Fourth Amendment talks about security, the standard way of asking this question is to ask, does the public or does the target have a reasonable expectation of privacy, right? So when we were talking about CCTV cameras earlier this morning, the argument is typically, well, there's no Fourth Amendment concern because it's all occurring in private and there's no reasonable expectation for the activities that occur out in the public and under those circumstances, right? The officer could have seen you just as well as the camera record you. Now, the problem, of course, is what ends up happening with this model when we ask that question is that the way the Supreme Court deals with this is we say that a search, and we all know it's a search, right, when the government's recording this information or gathering this information, it's not a search for the purposes of the Constitution unless there's a reasonable expectation of privacy. And if it's not a search for the purposes of the Fourth Amendment, then the court's per se warrant requirement, that a warrant has to be issued with probable cause, doesn't apply. And what's interesting here is that, well, what essentially happens is courts now essentially become the exclusive body that determine whether there is a reasonable expectation of privacy that we can enjoy. The difficulty has been, well, what happens? The way they ask it is often in the context of, is this the type of privacy invasion that the founders feared? And so the concern is this like breaking into locked drawers? Is this like rifling through my personal papers or kicking down the door of my home in order to gather the information? And as we've seen, often with new technology, that's never the case. Right? The invasion is dramatically different, if not completely sui generis. Right? The founders could never have anticipated CCTV cameras. They could certainly never have anticipated the internet, let alone Moore's laws and the massive amounts of information that private and public entities can collect about us. And so in many respects, if you care about privacy, then this is a problem from a constitutional perspective, right? Because one of the arguments is also, even if the state and federal government have laws restricting their particular uses or efforts to collect and use information about us, it's still not a constitutional violation if the government, in fact, goes ahead and does and collects that information anyway, because in the end, the courts have to make the determination if you have a reasonable expectation of privacy. Right, now, that might be fine if in the end you accept the idea that privacy is the sole goal and purpose of the Fourth Amendment. And I would suggest in many respects that that was essentially what led John Yoo astray when he was asked to provide advice about the President's surveillance program. What I want to argue here, and what I've argued now for unfortunately too long, is that it's about power, not privacy. And the Fourth Amendment has often been disconnected from the rest of our constitutional structure through invoking the concept of privacy. Well, what I want to argue is that it's not separate, but it is just part and parcel of an overall constitutional design that was designed to preserve the power of the people, right, popular sovereignty, in the ability to engage in law enforcement, security, information gathering, criminal prosecution, and any number of things that we find essential to the operation of our government. Right? And why do I do that? How do I do that? I may not be an originalist, though, however, as my students know, I will always argue that it's important to go back, at the very least, to the original understandings, not perhaps as a locked-in-stone rule, but certainly as a guidepost. And when you go back to the foundation trilogy of cases that every Fourth Amendment scholar, every scholar of criminal procedure will tell you, this is why we adopted the Fourth Amendment, they may talk to some extent about privacy, and one of the cases, Entick versus Carrington, is the clearest on that. But each one of them, Wilkes versus Wood, the writs of assistance cases, Entick versus Carrington, were all fundamental rejections of unbridled and unrestrained government discretion and power. Right? So in Wilkes versus Wood, the concern was that the Secretary of State could issue a warrant that would essentially didn't name any individual, and that there, as a result, the law enforcement could go ahead and find whoever they believed to be a problem and seize whatever papers they had to seize. The writs of assistance cases were allowing customs officials to designate other people to go ahead and again find contraband goods wherever they may be found. And the concern in all of these cases was always the idea that the government agent, right, however much they were acting in good faith, however much they actually genuinely believed that their suspicion and their targeting of this individual or this home was legitimate, nonetheless was acting without explicit governmental authorization and was acting without any supervision. So therefore, there was no restraints on who they could look at, who they could target, what information they could gather. And so certainly, and that's where in many respects we get the idea that the privacy of the home is important, right? So in Entick versus Carrington, James Otis was the first to raise the argument in the colonies about a man's home being his castle, which led John Adams to say this was essentially the first shot against British tyranny and oppression in the colonies. But every single one of these decisions has the more consistent theme of controlling unbridled discretionary power to search. Right. And more, when you then add to this another layer, none of these were criminal prosecution cases. They were actually all criminal trespass cases that were brought after the fact, in which civil juries then issued judgments against the individuals who had engaged in these activities. We raise another problem, which is that, as Akhil Amar has argued, judges weren't the tool. They weren't intended to be the protector for our rights under these circumstances, because the danger was if you actually had a valid warrant, you were actually insulated from these trespass actions, and then the civil jury wouldn't be able to award damages against you. So in many respects, a warrant was a bad thing in the days of the founding period. Right, so what does that mean for us now? Right, I have a couple of minutes, so let me hurry through this a bit. One is that there's essentially two problems when we're dealing with technological surveillance issues. One is kind of a macro level security question, and that is one that we rarely ever ask or address. And the other is a micro security question. Right, the micro one is the one we're used to. Was this search supported by probable cause or reasonable suspicion? Right, and so did it make sense for the government agent to target this person and look at them? The macro one is the idea of, is it appropriate? Is our society safe and secure when the government can engage in this kind of surveillance, whether it's CCTVs or the NSA surveillance program? And that has been completely subsumed by the Fourth Amendment question. The Supreme Court never asks a question of whether or not that program has been authorized in any other way, right? We are starting to ask that now as a separation of powers question, as a Youngstown Steel question. But it's generally assumed that the police department, the FBI can go ahead. Hey, neat new technology, of course we should use it. It's just whether or not we can get the dollars to use it. And then the question is whether or not when we use it against you, did we have sufficient reason to do it? So what happens with the president's surveillance program under these circumstances? Well, the macro question is a problem, right? I mean, in many respects, you would say without congressional authorization, all the searches that were conducted without warrants were unlawful, right? Unless you were to believe that the authorization of use of military force provided that express authorization, right? Under those circumstances, I think you'd have to ask, well, would it be consistent with the Supreme Court's most recent discussion on this topic, Kylo versus United States, where they said, well, the central question should be shifted in some respects from privacy in terms of the privacy invasion the founders feared, to the level of privacy and security that the founders actually themselves enjoyed prior to the introduction of new technology. And you'd also be governed by FISA, right? If you're looking in the world of Youngstown Steel, the fact that Congress had actually made an explicit statement prohibiting this type of search, this type of surveillance activity would in fact run afoul of presidential power. Now, the problem, of course, is once you have either the authorization of use of military force or the FAA come into play, you raise this. You may have eliminated the macro problem. Right? So now Congress has issued that blank check, but there's still the micro problem. Right now, it may be that Congress has given the president absolute discretion to engage in this activity, but there is no indication that the level of scrutiny against the individual is going to be constrained absent Fourth Amendment protection. And that's an oversimplification of many, many possible problems and issues. Those of you who are more curious about the arguments in detail, they'll be found both in these two articles as well as in the publication I'll provide after the symposium. So thank you very much.
All right, thank you very much. We have some time. We go till 2:30, so we have a little longer. We have some time now for questions and answers. Again, because this is also being webcast, please wait for the microphone to reach you before you ask your question. We can hear you here, but out on the web, and that raises a whole host of questions of what are we putting all this on the web and where does that take us. But if we have any questions, we'll entertain those now. So just raise your hand, wait for the microphone to get over to you, and we'll go from there.
Yes. I was just wondering what it would take to prove that one has been wiretapped, and I'm wondering could a person use their own tape recorder to and put the tape recorder to the receiver of their own telephone and record the telltale signs which might indicate wiretapping? Would that be admissible as evidence and give a plaintiff some standing in a court of law?
Have you been able to develop any independent evidence that shows a particular plaintiff having been?
Well, 2 points. So the first point is that it's possible, I suppose, that in some very, very novice and amateur kinds of situations that there would be clicks on the wire, but in modern intelligence surveillance and law enforcement surveillance, they tap at the switch and they are able to simply split fiber containing signals at where the telephone company is. The evidence that we use in our case, in the Hepting case, is essentially about fiber optic splits, and so it will not. And in fact, under the CLIA requirements, all of the lawfully authorized wiretapping is supposed to be undetectable to the target. So that's normally when we get calls about that, we say if you think that those clicks mean you're being surveilled, it probably doesn't. So the other point is, how would you go ahead and prove it? In our case, for instance, in Hepting, because what we did was we had whistleblower evidence about a widespread practice by AT&T of secret rooms in which this data was being fed for NSA access, and we had technical documents of AT&T that set this up. Then when we went to our judge and he faced the question of, well, do your plaintiffs have standing? Essentially, he used sort of an environmental analogy. That is, this is an alternative to Jameel's strategy on standing, is that if, say, you have a lake that is polluted, and perhaps the pollution is something that takes 10, 20 years to actually manifest. But you can, in many of the environmental cases, they have granted standing based on the showing of a heightened probability or heightened expectation of risk associated with your being near that facility. And that's essentially the theory that was used in our case. That is, our plaintiffs are near a facility with a known facility, and based on our expert evidence that tended to show that all or substantially all communications flowing through that facility were being intercepted by the government. Therefore, there was, at least for purposes of surviving a motion to dismiss, an adequate showing that there was that the plaintiff's interests were harmed.
Another question? Well, I'm going to exercise my prerogative as the moderator and ask one. And one of the pervasive themes that seems to be coming through with the state secrets is that if we tell you we've been doing this, you're going to understand how this works, and you're going to be able to identify the materials we've collected, things like that. And I wonder if there's the inverse of that, which is sort of the peniological theory of the panopticon, which is that if you develop a prison system in which it is capable of surveillance of all of the inmates at any time, where they can't know when they're being surveilled, you actually then don't have to do any surveillance because they'll self-regulate because they don't know when they're being watched. And is that part of the strategy you're seeing from the government, is that actually by revealing to you either that you weren't surveilled or that our surveillance is completely ineffective, it would reveal the holes and therefore reveal the state secret that our surveillance is incompetent?
Well, that's actually exactly the theory that the government advanced in Hefting. Again, they said, if we tell the terrorists, and again, their framing of it is not that we're not interested in spying on Americans. That's their story, right? Their story is we're interested in catching the terrorists. And so we don't want to tell the terrorists that, AT&T is the one that we are using as the giant wiretap, because then they'll avoid AT&T. And so in oral argument, for instance, Judge Walker, who is not an idiot, said, well, with this case, alone, and with the allegations against AT&T, wouldn't any, intelligent terrorist who actually thought about these things avoid using AT&T anyway? And the government's argument is, well, maybe some would, but you have to do this sort of marginal terrorist analysis. And, no, I'm serious. They actually use that phrase. I mean, it's wonderful to see law and economics in this context. And that was the way they tried to finesse this. And of course, then the other natural question is, well, if you are in fact using all of the carriers, then of course there can't be any getting around it because they're all going to be subject to it. But in any case, what they ended up always arguing is precisely that we do not want to reveal our sources and methods to those who we're trying to catch.
Oh, there we go. Hi, Raymond. I'm wondering if you have, if it keeps you awake at night at all, that essentially what we're building is the mechanisms of an authoritarian society that is on steroids. Like we've never seen the mechanism for this amount of social control anymore. Do you have any queries about the sense of, as long as the laws authorize, given that, of course, it is the government that makes the laws? And every time we see a new surveillance program, and again, electronic healthcare records is a perfect example, right? All the rules up front are exactly the rules that are going to be repealed as soon as the architecture is in place. So is there some kind of limit that we should just say, actually, this piece is not even in the magic chalk circle of possibilities because of that balance of power, checks and power that are required for democratic process?
Well, absolutely, it concerns me. And, when I say that I've been trying to shift the frame from privacy, I'm saying that because I'm concerned that privacy and the reasonable expectation of privacy test that we have is essentially inverted the power relationship that's supposed to exist in a constitutional regime of government. Right now, the people that make the decision of what level of security we get to enjoy is the executive branch initially. And you're sure they're elected, so we can vote the bums out every couple of years. And then the judiciary, when they often rubber stamp and approve what the executive is doing. Now, is the legislature an ideal source of control for this? Right? Academics, we generally like to say no, right, that we may know more. But no, I mean, in our system of government, I think it has to flow first from the legislative branch and continue. And for me, the backdrop is always going to be, in the baseline safety net, is the Fourth Amendment. Right? So there, in our Constitution, we have set out very clearly what is required for government to engage in surveillance of an individual, right? And it's the warrant clause. It's the idea that searches should be conducted when we have probable cause. And it may be that there's, in my article I talk about, there have been other theories proposed that maybe we could relax them if they're administrative rulemaking, right? So the law enforcement has its own procedures. Or if Congress comes in and says, well, we want to relax the standards for a FISA warrant or for the surveillance, I'm troubled by that in the end when the document that is the Constitution is not supposed to be a majoritarian document. It's supposed to be a document that protects all of society. And so I think that the Warren Clause is very fundamentally a way of doing that until we actually amend the Constitution. So I agree. I mean, this is creeping, right? But my concern is how do we fight the creep? Right? And it's not by going to necessarily and claiming we have a reasonable expectation of privacy in this, but it's that we as a society, as a democratic government, must respond in the absence of our initial authorization. The default is the Constitution, right? And the executive branch has to act very carefully when it's not acting with our authorization.
How am I going to say this? Prior to the amendments to the FISA Act, the FISA court acted at least as a theoretical gatekeeper, constitutional gatekeeper, although I think over the years they had only denied 1 or 2 requests for a warrant. So as a practical matter, they may not have even acted as a constitutional gatekeeper, but at least in theory they did. With the amendments, is there any function, useful function, that the FISA court plays at all anymore? I mean, if you can go out and get a warrant based on some kind of location, it's theoretically possible that a conversation could occur between someone in this country and someone in any location, anywhere in the world. Why even bother with the FISA court anymore except to act as a kind of a fig leaf for uncontrolled government power?
Is this like indicting a ham sandwich?
Yeah, I mean, as to the question, what the FISA court's role is, I mean, you're right. Until the FISA Amendments Act, the FISA court had a role in overseeing surveillance on an individualized basis. I think that there were 22,000 or so surveillance applications between 1978 and 2001, and of those, only 1 was denied. There were a handful, 4 or 5, that were approved with modifications. Only 1 was denied. So its role was limited even before. And now its role is, I think it's an exaggeration, an overstatement to say that its role is marginal. All it does is determine whether the government's targets are located outside the United States. And to determine that, it just asks the government whether its targets are located outside the United States. I mean, there is another requirement, which is the minimization requirement. And the idea is, the basic idea is that the stuff that isn't important to foreign intelligence should get thrown away. It's a back-end protection. But the way that foreign intelligence information is defined, so the stuff that they can keep is called foreign intelligence information, and that category is so broad that it encompasses virtually anything that might be, any information that might be exchanged between, for example, a lawyer and his client abroad, or a human rights researcher and a source abroad. So it's not really much of a safeguard at all. So that's to say that I agree with your fig leaf analogy.
I wanted to sort of amplify that, beginning with the fact that for as long as I've been a lawyer, I was always very, very skeptical about the constitutionality and effectiveness of FISA. It is a sad thing to say that today I wish that we still had the 1978 FISA in play, because deficiencies aside, was definitely the lesser of two evils. I mean, I think from what we have heard from the intelligence community, they did apparently take the fact of review by the FISA court into account, and so there was, at least when there was no active conflict, no active war, they were deterred to some extent in abusing those powers. The last few years, that we know about, though more and more abuses were coming, right? That's why the FISC started to get very, very upset with the way things were being done under the Patriot Act, under the pressure of the Al-Qaeda issue. But today, they review targeting procedures. I mean, they review procedures for whether or not they are likely to reasonably be, hitting U.S. persons. It's not even clear that the carriers that are being asked to carry this out. There was one case. I mean, one of the things that the FAA allows a carrier that receives the directive to then challenge it. They're the only ones that can. And somebody did. Much of the litigation was completely outside of our view, but from it you can sort of tell that they did not know who it was that was being targeted, and that the only things that the court were looking at were essentially there's no meaningful check in the process right now, which is why the bills that are going through. There's one bill I think in the House right now, right? It's the Conyers and Nadler bill would attempt to put in some more protections. It seems to be the best that anyone's trying to do right now.
Okay, we'll take one last question and then wrap up for the session.
I'm just wondering, what is the ability of the government's? What is the extent of the ability for the government to put surveillance over ISP gathered information and voice over IP communications? I mean, I'm just wondering. Does that make any
Technical ability or legal ability?
legal?
Well, legally, right? They can tap. If they get an interception order, they are fully able to gather voice over IP calls, because those are simply electronic communications in real time under Title III. And as far as other kinds of informations, those, like with ISP records, those are all stored communications or stored communications records, or for purposes of NSL statutes, electronic communications transactional records that are all sort of covered under the law. So there's certainly nothing that they can't get if they follow the rules.
Mm-hmm. I think that Tim Casey is going to talk a little more about NSLs on the next panel. Right.
Okay. All right. Well, thank you very much. We'll take a short break.